Thank you, Catherine and Jane, for organizing this, and anybody else who was involved in organizing this. So I am a professor at Georgetown University Law Center, where we have an asylum clinic, and I teach immigration law and policy. And there's a very active student body engaged in working with immigrants and asylum seekers. And I will tell you that one of our groups was just out with Erica's organization, Al Otro Lado, in San Diego and Tijuana over spring break. Um, so the students are heavily engaged. I want to start, though, by talking about representation from the point of view of the asylum seeker. And then I'm going to tell you a little bit about the research that colleagues in the field have done. As Susan indicated, I had done this research on representation going back many years and at different points, but we've got even better researchers who have been conducting very extraordinary studies. So I'll tell you what they've learned. But let's start at the beginning. Imagine you receive a document from the Department of Homeland Security in a language you don't understand. You can see your name on it, and somehow you figure out that it tells you you have to be at a certain location at a certain time. Let's say you figure out what that location is, and you enter a courtroom where the judge is speaking a language you don't understand. You have no idea what you're supposed to do when you get there, and you don't know if you were supposed to bring something with you. You brought the piece of paper that you had, that the government sent you. You don't know what will happen while you're there. And you don't even know if you can bring your child with you since you don't have childcare. Most asylum seekers who are summoned to immigration court in order to pursue their claims have no idea what's going on. And unless they have competent counsel to help them, they'll never know. Most asylum seekers don't come to their very first court hearing with an attorney. They walk into a room where there are about 30 to 50 other people, including families, from different parts of the world. There are a few people dressed in professional attire. And then a person in a black robe enters and sits up front looking out on everyone else in that room. 3 hours later, the judge has cleared the room. All the cases have been handled. An interpreter asked you some questions about your citizenship, whether you entered the United States on a particular date in a particular location, and whether you were admitted or paroled after inspection by an immigration officer. You don't understand what that means. You were then told by that interpreter to try to find a lawyer and return to that court. You still don't understand what's going on. What I've just described is the beginning of removal proceedings. And most asylum seekers do not know either their rights to make any
Hear it
claim
at all.
But that's okay.
or how to do so in deportation
I think
proceedings.
I'm gonna walk down to the car and take some pills.
Okay.
They do have the right to assert that they are refugees under the law enacted by Congress and the treaty that Congress adopted to protect refugees. If an asylum seeker thinks that they may be seriously harmed if they were sent back to their country because, let's say, of their religion or political activity or their gender, for example, they can claim asylum as a form of relief from deportation. Do asylum officers need lawyers to do so? How else can they learn how to explain to a judge and present evidence that they have a well-founded fear of persecution, serious harm, on account of might be their race, their nationality, their religion, political activities, or membership in a particular social group? The bottom line is that whether they are unaccompanied children, which we have a significant number of, or adults, there's no way for them to navigate the adversarial system of immigration court without a competent attorney. But first, let's focus on what the research tells us as to why representation matters in immigration court removal proceedings. One of the seminal studies conducted by some colleagues about 10 years ago showed that it was 15 times more likely that an asylum seeker would seek relief if they were represented. If they weren't detained during their time in immigration court, they were 4 to 6 more times more likely to gain asylum, to be granted asylum by the immigration judge if they were represented. My study found that back in 2000, and many have found this since. If the asylum seeker is detained, another organization study has shown that those who were represented were up to 12 times more likely to achieve successful outcomes while they were detained. The bottom line is that not only does it matter to the refugee and her family, it also matters in terms of U.S. compliance with the refugee laws and treaties. Well, the first problem is that despite how much representation matters in asylum cases, there is no right to counsel at government expense for indigent immigrants. And we're going to look at the challenges of finding competent counsel in just a bit. But first, let me tell you a little bit about what the research has shown us as to who is and who isn't represented. One of the leading studies on this, again about 10 years old at this point, but it involved over 1 million cases, pretty robust. And they found that at that point, 63% of all those in immigration court at the time, and this is beyond asylum, it's not just asylum seekers, but 63% were not represented. And if they were detained, it was even a greater percentage, 86% were not represented who were detained. Now, I mentioned before that I direct an asylum clinic along with another colleague at Georgetown Law. There are a decent number of asylum clinics around the country, and we have a good number of pro bono lawyers in the country, but very insufficient. At the time that this study was done, pro bono lawyers in clinics only accounted for believe it or not, 2% of the representation. I think the pro bono representation is higher now, but it's still insufficient. And the study also found that the availability of counsel is much more challenging in rural areas and small cities, which actually make up about a third of the cases. We'll get a little more into that in just a bit. There's another excellent study that focused on detained families seeking asylum. Now, this is a phenomenon that took place somewhat under the George W. Bush administration and under the Obama administration after it decided first not to detain families, then it decided to detain families, and of course under the Trump administration as well. And the study, which was done in around 2018, so it included what was happening to some degree during the Trump administration, found the following. First of all, some families over this entire period were released from detention during their removal proceedings, but others were not. It turned out that about a third were detained for the duration of their immigration court proceedings. The families that were released were more likely to find representation. About 3 out of 4 did, as opposed to 1 out of 2 if they were detained. Actually, 1 out of 2 if they were detained is a much higher rate of representation than generally happens for detained asylum seekers. Perhaps because they were families, and perhaps because of where they were being detained. Then the really important findings about how did this matter. The families that were released and that found counsel prevailed about half the time. And even those who were detained and found representation prevailed a little more than 1/3 of the time. But that turns out to be 5 to 7 times more than those who did not find counsel, because only 7 to 8% of the families who didn't find counsel won asylum. And it didn't actually matter that much whether they were released or not, if they didn't find representation. And then it turns out there's a wide variation in outcomes by judges and jurisdiction. In other words, what immigration court you're in. There are over 60 immigration courts right now. And that also reflects the availability of local attorneys. The experience of an asylum seeker who's detained is very different than one who is not. In so many ways, I mean, of course, your liberty is taken away from you. But in terms of the actual case and the hearing, it turns out that almost all detained immigrants and asylum seekers, including families, don't appear in court before an immigration judge if they're detained. 93% of the immigration court cases involving families were conducted remotely by video. About 96% of the released families applying for asylum attended all their hearings. So we've known this for this phenomenon for a long time now. The study started finding that in the 1990s, actually, that many asylum seekers believe that they have a chance to show that they're refugees and they will show up at their hearings. And that's what that research showed as well. So let's talk for a moment about what the major barriers to representation are besides cost. Now that you know how significant this representation is, what it means in terms of raising a claim, knowing what claim might be raised in your defense in a deportation proceeding, but also in terms of the outcome. Did you gain asylum or did you not? What are the barriers in finding a lawyer? Well, one is knowing how to find a lawyer, let alone a competent lawyer. How do you do that? If it's based on word of mouth, maybe you'll be lucky, maybe you won't. And as immigration judges will tell you, and you can observe if you go to immigration court, there's a tremendous range of lawyering that takes place in immigration court. And it does depend on the jurisdiction, but in the jurisdiction I'm in the Washington, D.C. area, Virginia and Maryland, yep, it definitely depends on which lawyer you have. I know in New York it does, and in many other parts of the country. Not necessarily all, but in many. And then second, there's the limited availability of immigration attorneys who practice in court. As it turns out, most of the immigration bar focuses on legal immigration applications. They don't do what we call immigration defense work. In other words, defending an immigrant in immigration court who believes they have a claim to be able to stay in the United States, particularly asylum. In terms of finding a lawyer, it's much harder for those who are detained, and that's no surprise to anyone. How do you communicate with the outside world? That's a great challenge for somebody who's detained. And of course, many are detained in our country in rural areas. So based on location, it really can be very difficult. For the detained, there was less than 1% representation in the Tucson jurisdiction as opposed to as much as 25% in Miami. I think that's because that included immigration courts that were in or near Miami. For those who aren't detained, cities like Atlanta and Kansas City, almost half were represented. But it's as much as 8 out of 10, almost 9 out of 10 in San Francisco and New York. So where you are really matters. Nationality. There's a tremendous range in the success of various nationalities in finding representation. For Mexicans and Hondurans, it's about 21 and 23% respectively, all the way up to 92% for Chinese. And so it really depends on where you are, whether or not you can figure out how you negotiate this to try to find counsel, whether you're detained or not, what community you're a part of. And again, I haven't even been talking about whether or not you found competent counsel, just that you found counsel. And those studies that I've recited, by the way, about the success rates of grants for asylum, if you're represented, they also don't break that down by competent counsel or not. So it takes into account a range of qualities in counsel. I want to just say a couple other words and then I'll stop. And first is that there have been, so I should say something about the value of law school asylum clinics. You can imagine what I said earlier. the asylum clinics are not representing large numbers of asylum seekers. What's the real contribution? Training the next generation is how I would put it. So our asylum clinic is very intensive. It's 10 credits for the semester, which is like a full-time job, like 3 courses. And students are in charge of the case and responsible from the beginning to the end of the case. And many have told us, because they've had that responsibility, they've developed the relationship with their client, the asylum seeker, which may be an individual or a family. Many have told us that it's a life-changing experience for them. But it's only 12 students each semester. Maybe about a quarter of them go on to work in the field, often starting out by representing asylum seekers. Others go on to law firms and do the same pro bono. Okay, so some do really stay in the field in some ways. I just want to close with 2 major types of representation developments that I think are very meaningful before turning it over to my colleagues, whose work I think we'll all learn a great deal from and whose organizations are extraordinary. The first major development is an organization called the Immigrant Justice Corps, which is actually set up to train the next generation. They will take law graduates in their early years, either immediately after law school or after a clerkship, and for 2 years um, they pay their salaries to work with the great advocacy organizations around the country. It started in New York, it's spread throughout other parts of the country as well. It's a 2-year fellowship, and they do some very good training as well. The second development happened several years ago and continues now, and that's a universal representation model. So if there's a problem in obtaining counsel, universal representation, short of mandated counsel paid by the government, would be an excellent alternative, and perhaps a better one for all we know. The New York Immigrant Family Unity Project developed this in several years ago. It's a universal representation model funded by New York City. I think they may get state funds as well now, not federal funds. It's a lot of it is local. And that's now been replicated in other cities. So those are excellent developments, but still we're in a situation where too few asylum seekers and others who may have claims to be able to stay in the country are represented. Thanks.
Thank you, Andy, for providing us such a very good overview of the issues. I'm going to move to Lisa in a minute, but I do want to remind people, and some of you have already started putting questions in the chat box, but please, as you're thinking about questions, please do put them in the chat box, and then we'll have the Q&A following the third presentation. So Lisa, please go next.
Thank you, Susan. And thank you, Andy, for setting up this conversation and providing such an insightful context to the issue before us. My name is Lisa Coop. I'm the legal director at the National Immigrant Justice Center. NAJC is based in Chicago, where we provide legal representation to low-income immigrants. So all of our clients are at or below 200% of the poverty line. And while we are based in Chicago, we have satellite offices in Indiana, and we have a small outpost in San Diego. We have a policy shop in Washington, D.C. And we've been pretty intentional about trying to support the work happening on the border in recent years. And in particular, during the Trump administration, we partnered pretty closely with organizations working along the border in Laredo. So we were doing work during family separation with primarily mothers who are in detention, separated from their children, conducting their asylum hearings while separated from their children, in jail cells, remotely, as Andy described, by video conference to judges sitting hundreds of miles away. And we also represented clients in those migrant protection protocols, the Remain in Mexico program, where we were literally in shipping containers with our clients just north of the river, trying to provide representation to people who were forced to wait in Mexico in very perilous situations. And so As we have this conversation today and sort of anticipate the coming months and the upcoming elections, in very front of mind for us is concerns that as difficult as our asylum system is right now, we face some real obstacles before us, depending on how this election shakes out. So, not to begin with too much doom and gloom, but our asylum system is really problematic, and it doesn't need to be. There are things that could be done to remedy the system, to make it a more just process, to infuse due process. Things like providing better access to representation would be life-changing for so many people. At NAJC, our asylum project is one of the types of legal services that we provide. It's a big project. It's been part of what we do and really the fabric of NAJC since our inception. And we provide representation in a number of different ways. So we do in-house representation. So we have lawyers that directly represent asylum seekers. We calculated recently it takes a seasoned immigration attorney probably somewhere between 80 to 100 hours to prepare an asylum case. And that's if you're moving at a good clip and things are falling in the right way. And so the number of cases that any individual attorney can take is somewhat limited because it's such a big resource-intensive undertaking, and because cases take so long to resolve. In Chicago right now, if I meet a client and they've got their notice to appear telling them when they're going to have their initial court hearing before the immigration court, it's very possible that that document will have a date in 2027 already. And so the idea that we can move someone efficiently through the system and help them access justice and help them stabilize and be safe and be with their families and remove this fear and anxiety of being returned to a country where they face harm, that's very remote right now in our immigration system. That takes a really long time. And as you can imagine, the longer it takes to resolve a case, the more difficult it may become. The trauma and the anxiety that the family experiences continues while their evidence grows stale, while their memories start to fade. So the backlogs in the immigration courts are a real challenge for us, and something we'd really love to see this administration work more diligently to resolve. We think there's a sweet spot. The pendulum can't swing too far. We've seen them make efforts at really, really expedited proceedings, which we also are very problematic. But the backlogs to really make justice inaccessible for a lot of our clients. So I mentioned we do cases in-house with our NIJC attorneys. We also work with about 2,000 pro bono attorneys. So those law students that Andy is training who are going off into big law and going to law firms, we hope will connect with us and agree to take an asylum case placed by NIJC, where we will recruit and train and support and co-counsel with pro bono attorneys for the life of a case. And they typically do a really good job and have the resources of a law firm to put towards an asylum case. So if we can get an asylum client matched with a pro bono attorney, that's usually a pretty good scenario. And there's something really fantastic about all of those big firm resources being directed towards an asylum seeker who probably comes from pretty humble backgrounds. And gets to walk into a fancy law office and have those resources used on their behalf. We also work with law students. I'm an adjunct professor at Notre Dame Law School. So every semester we have 4 to 6 law students who do asylum trials, handle asylum cases, and provide representation. And part of that is because in Indiana, kind of what Andy was suggesting, in rural areas, it's a lot harder to find attorneys to represent asylum seekers. So being able to help our Indiana clients through our law school program is really exciting. At NAJC, we also run an immigration court help desk, which is a resource available to pro se asylum seekers. So pro se is the Latin word for representing yourself or going on your own. If someone is pro se, that means they're appearing for the judge by themselves, and they're doing kind of what Andy suggested, sort of showing up at court with their notice to appear and maybe a few other documents and trying to make it through the process on their own. And organizations around the country have been funded through the federal government to run these help desks where people can come and ask us questions and get some guidance. And we're under no illusion that that's sufficient, that really, will get someone across the finish line. But our hope is that by providing that sort of guidance at the outset of someone's case, we can keep them moving in the right direction. help them understand, for example, that you've got 1 year to apply for asylum. So even if you show up at your first court date and the judge tells you to come back 18 months later, you know that you've got to get that asylum application on file before you hit that 1 year deadline. So those are some of the ways that we approach the work, the support for asylum seekers. And I'm going to talk in a moment about a newer model that we've come up to try and respond to the needs of asylum seekers in Chicago. Right now, we're one of 5 cities or 5 or so cities nationwide that are receiving a lot of buses coming up from Texas. I'm sure you've all heard about this. And so we have a really high number of pro se individuals, unrepresented individuals who are wanting to seek asylum and who have asylum claims and need to apply for asylum. And so because we don't have enough attorneys to match every asylum seeker with a pro bono attorney or an NIJC attorney or a law student, we've been experimenting with pro se models, with clinics where asylum seekers can come and have their I-589, which is their asylum application, completed by an attorney, sitting down with someone who can at least, put some legally trained eyes on their application in preparation of their case and get them moving in the right direction. And we know that that's a far from perfect model. In an ideal world, every asylum seeker would have representation. But that's one of the ways that we're trying to address the high need and the real gap between the need for services and the availability of attorneys. I think it might be useful to talk about what actually happens in immigration court and what the value is of having an attorney. What is it that we actually do when we go to immigration court? Many times we're preparing documentation somewhere in the ballpark of 300 pages or so when we're filing supporting documents in support of our asylum claim. I tell my law students if they're getting much over 300 pages, then the judge probably isn't going to read it. So we try and strike that balance. But really the work of representation is learning your client's story and helping the asylum seeker understand how to tell their story. So often an asylum seeker, when you first meet them, if you ask them, what are you afraid of? Why can't you go back to your home country? They'll say something like, it's not safe for my children, or there's delinquency, or there's poverty. And they'll say the sorts of things that don't really fit into that refugee definition. In order to win asylum, you have to establish that you meet this definition of a refugee. And asylum seekers, oftentimes without counsel, really struggle to understand what are the parts of your story? What are your salient facts? What are the things that you need the judge to know so the judge understands why you need protection and how your case meets that definition under the law? So a lot of what we're doing when we're preparing asylum cases is helping our clients understand the ways in which they need to tell their stories in order to establish their legal eligibility, that they meet these elements of asylum and should be granted protection in the United States. We're also gathering corroborating evidence. Since 2005, under the Real ID Act, an immigration judge can require any evidence that they think is reasonably available. So they don't tell us beforehand, hey, we reviewed your documents and here's the list of evidence that we think is necessary for you to win your case. You kind of have to discern from the universe of possible evidence what your judge is going to require and make sure that you have those pieces of evidence available, or that you can explain why they're not reasonably available. So we're talking to our clients a lot about who are the witnesses, who can tell us, who can confirm what happened to you. For our clients who have marks on their bodies from the harm that they've experienced, can we get a forensic medical exam? Can we get you into a doctor who will document that harm? For people that are experienced post-traumatic stress disorder or other cognitive disorders, we're getting forensic cognitive exams, and we're building these cases that are quite complicated and quite involved to collect the sort of evidence you need to win a case. That's the work. And imagining someone trying to do all of that on their own, the system's just not set up to access justice without an attorney in our asylum system. So I think I'll shift a little bit. So when we're working before the immigration court, we're building this case, we're going into trial. This is an adversarial process. So when we go into court, when we have an asylum trial, we're representing our client. On the other side is a prosecuting attorney, a Department of Homeland Security attorney, whose job, who often views their job not as determining what is the just outcome, but they call it poking holes and trying to figure out how to show that this person shouldn't be granted asylum. And so I was in court a couple of weeks ago with on an asylum case, and I said to the DHS attorney as we were starting the hearing, like, hey, I think we've met our burden on the papers. Like, I think you should consider stipulating to asylum in this one. We've got a good case, we've got credible evidence, we've got corroboration. And he kind of looked at me quizzically and said, well, what would the point be in that? Why, we have trials for a reason. We have to go through this whole process. In my view, oftentimes subjecting our clients to the indignities of cross-examination about the most intimate and horrible details of their lives, rather than having a meaningful process where we do pretrial conferencing, where the parties are looking at cases and determining, again, what is the just outcome here? Have we met the burden in this case? Can we avoid going to trial? Can we reduce those court backlogs by resolving cases outside of court? These are the sorts of things that a healthy system of justice would have that our current system does not have. And so we go through our asylum trials, and as Andy suggested, because we like to believe we're competent attorneys, we win most of our cases, but we are so painfully aware of all of the people who we aren't able to represent, who do go through that process without counsel or without competent counsel. And that's really heartbreaking to know that we're not reaching everybody who needs our services. I'll maybe shift briefly and talk a little bit about litigating asylum in the federal courts, which is another thing that NAJC tries to do in order to work systemically so that the law is changed in a way that helps all asylum seekers, including asylum seekers who are appearing pro se without attorney. So when we appear before the immigration court at the IJ level or the trial court level, in my mind, our aim is to win asylum for our individual client. And then I'm hoping a secondary outcome is that we will teach the immigration judge, we will help the immigration judge to understand that these sorts of facts amount to an asylum claim. So when that judge sees a similar case where maybe there's not an attorney present or not a good attorney present, that judge will have the foundations to find their way to granting asylum in some of those cases. When we're litigating in the federal courts of appeals, for us, that's most often the Seventh Circuit, which is the federal court of appeal for Wisconsin, Illinois, and Indiana. There we're trying to change the law or protect the law or do things to the law so that judges will recognize that, again, these sorts of facts, these sorts of cases amount to an asylum case. And this is, for example, a particular social group. So Andy mentioned these different reasons that people can win asylum: their race, religion, their nationality, their political opinion, or their membership in a particular social group. They've got to show that there's something about them that they can't change or they shouldn't have to change that is causing someone else to want to harm them. And that person that wants to harm them either has to be the government, an entity of the government, or somebody that the government is unwilling or unable to control. That's the goal. That's what we're trying to establish. And so when we go into federal court and take on courts of appeals cases, our aim is to clarify what that means. So one case that we litigated a few years ago that has done that is a case called WGA v. Holder, where our client, we represented him in immigration detention, and so, sure enough, he was denied asylum by the immigration judge in detention and lost at the Board of Immigration Appeals. He was a Salvadoran man who was targeted by gangs in El Salvador because his brother had fled the gang. His brother had been forcefully recruited by the Salvadoran gang. Brother had fled. The gang came to the family home, put a gun to our client's head and said, "You need to turn your brother over to us. You need to show us where he is, or else we're coming for you." And he fled, and the immigration judge was like, that just sounds like general violence. That's just the harm everybody in El Salvador is exposed to at the hands of the Salvadoran gangs. That's not asylum. And the Board of Immigration Appeals, which is the next level that you go to if you don't win before the immigration judge, agreed and kind of rubber stamped that decision by the immigration judge. We went into the Seventh Circuit, and the Seventh Circuit was like, after litigation and oral argument, they concluded, like, hold on just a minute. First of all, what happened to this guy is persecution. This is the type of harm that we consider persecution. Having someone hold a gun to your head and threaten to kill you is harm that we recognize as persecution. And it's happening because of his familial relationship to his brother. And so they recognize these family-based particular social groups in that case, and subsequently in several other cases that were published in the Seventh Circuit. And so now when we go into immigration court in Chicago, which is controlled by the law of the Seventh Circuit, when we make these family-based particular social group arguments, we're often successful and other people are successful. And I believe pro se individuals can be successful because the litigation was in this case resulted in a published decision finding family-based particular social groups as cognizable. So that's just one example. And I want to make sure that Erica has a lot of time to talk to you about the really outstanding, fantastic work that her organization is doing. So I'm going to turn it over to her. But I did mention that we have started these pro se immigration clinics in response, or sorry, yeah, pro se immigration workshops in response to the arrival of southern border arrivals or recent arrivals from the southern border coming to Chicago, usually by bus. And that's been a really interesting experience, and I think has largely been successful at this point in getting people a competently completed and filed asylum application, in getting people moving towards employment authorization, which you can only access if you have had an asylum application pending for at least 150 days, and then you can't get it until 180 days. And so we're hopefully helping people stabilize and helping move their case in the right direction. And our sincere hope is that by the time people arrive at their asylum trials, they'll be in a position to either hire a private attorney or connect with a nonprofit and find a pro bono attorney in order to more meaningfully be able to pursue their asylum claims. But I will pause there and kick it over to Erica.
Thank you, Lisa. Yes, please, Erica, your turn. And thank you both so far, Andy and Lisa, for keeping to the time. So we should have plenty of time for questions at the end. So Erica.
All right, thank you so much for having me. Again, my name is Erica Pinheiro. I am the executive director of Al Otro Lado. We are a binational organization with offices in California and in Tijuana, and we provide both legal and humanitarian services on both sides of the US-Mexico border. So I want to describe a little bit about our programs. I'll kind of start from north to south. So we have a LA office. We get a lot of federal, state, county, and city funding to represent migrants both in immigration court. So it's a lot of asylum cases, this defensive representation that the speakers referenced. And we also do affirmative cases. And that's basically when someone's applying for citizenship or residency, but they're not in immigration court. And so our model is really to bring someone from, the time they come to the United States all the way to citizenship with social service supports as well. We also have a San Diego office. We also do representation there. And I want to mention too, we represent a lot of detained individuals from both offices. In San Diego County as well, we have a growing humanitarian program. About a year ago, maybe 6 months ago, Border Patrol started releasing about 1,000 people a day to the streets of San Diego. So there's just a lot to do in terms of orienting people, documenting when they've been separated from family members during Border Patrol processing. Border Patrol has also started holding individuals in open air detention sites. So these are places where asylum seekers are crossing the border and they're turning themselves into Border Patrol, and Border Patrol has them wait for hours or even days without food, water, or shelter or access to medical care. So we have been providing humanitarian relief in those camps, as well as doing some legal work to try to end the practice of holding asylum seekers in open air detention. And I'll talk a little bit about that in a few minutes. We also have a legal orientation program in Imperial County, California. We have an office there in Calexico. So legal orientation is a federally funded program We work inside of an ICE, Immigration and Customs Enforcement detention facility, which is basically a prison. And this particular facility, because it's so close to the border, is almost all asylum seekers. So we have people from dozens of nationalities speaking dozens of languages, which is challenging in terms of providing adequate services because there's only 4 people on the legal orientation program team. And it's also very challenging because this is the first step in accessing asylum, which is the credible fear interview. So this is before someone gets to court. It's essentially a screening interview to determine whether or not the person could apply for asylum. And usually in this particular facility, people are getting those interviews a few days after they arrive. So sometimes we're not able to catch them before they're getting that credible fear interview. Again, there's a lot of challenges in providing services in all of the languages that are represented there. And these are not representation programs. This is just legal orientation. So it is pro se assistance. It's for people who are representing themselves. It's very difficult as well because detention is not a nice place. You are in a prison. It's difficult to communicate with the outside world. You can't call your home country to try to get evidence. In many cases, you don't have internet access. If you don't have a contact in the United States who can help you get your evidence or help you hire an attorney, it's very difficult. And again, this is a very expedited process. It's part of a process called expedited removal. And so the idea is people get this screening interview. They have only 4 days to prepare everything. If they have evidence, it needs to be in English. They have to explain their story to an asylum officer. If they pass, then they are able to apply to be released from detention and go on to fight their case before an immigration judge. Some are not released from detention and end up fighting that case in the detention facility. As I think Andy mentioned, in this particular facility, it's remote. They're appearing remotely, so they're just in a little room by themselves with the judge, usually their attorney, just on a video, which sometimes works, sometimes doesn't. The sound doesn't work a lot of times, etc. So it's a challenging environment for anyone, especially with such an expedited process. We also have a family reunification program. So we are still working to reunify families that were separated under the Trump administration. I think there's around 800 left who were deported without their children. And so we are helping those individuals return to the United States to reunify with their children who are still here in the US. Some of them have been separated now going on 6 years. So it's really difficult for everyone involved. And the process itself is also very difficult. And again, not enough attorneys to help people in that situation. And it's quite a complex process. We also have a few programs in Mexico. So our biggest program in Tijuana is the Border Rights Project. So the Border Rights Project is largely a pro se assistance program. We provided information about how to access the asylum system to over 15,000 migrants last year, most of whom are in Tijuana, but we also do remote services for individuals in other border cities, especially those that are too dangerous to have on the ground legal service providers. So that consists of workshops. We have 2 workshops a week in Tijuana. We also have remote workshops where we are helping people who want to seek asylum in the United States access that system. So the law says that people should be able to present themselves at a port of entry. Unfortunately, for many years, the US government has not allowed individuals to do that freely. This is a subject that we've been litigating since 2017. So basically, right now, the only way to present oneself at a port of entry is to get a smartphone app appointment. It's called CBP1. It's only available in a few languages. It's very glitchy. It's difficult to navigate. So a lot of what we're doing in Mexico is telling people about the app, helping them navigate it, but also telling them about the US asylum requirements. They are a bit different from those in Mexico. And so in some cases, people are better off trying to apply for asylum in Mexico. They have a higher chance of seeking some kind of protection. But I will say, even those who probably don't qualify under US law. By the time they're in Tijuana, they want to try. And that's for a few reasons. One, almost all of them have family in the US who can help them through the process. And two, Tijuana is one of the most dangerous cities in the world. And we see many of our clients and other migrants who are forced to wait in Tijuana and other cities fall victim to organized crime, official extortion, just all kinds of violence that's directed against them in Mexico. And they have very little recourse to seek justice with the Mexican authorities. So it is quite challenging even to get into the system, which, you know, then is challenging if you don't have an attorney. So I want to say a little bit about, oh, one more thing. We have a program for deportees as well. So almost all of our deported clients were the main breadwinner for their families in California. I think there's around 1,000 people deported to Tijuana every month. And there's no public assistance, like no public program in Mexico to help with reintegration. So a lot of times it's people who, you know, don't know if they have a chance to go back to the US legally. We also find US citizens who have been deported sometimes because the system is so expedited and because people don't have access to counsel. In some cases, US citizens are swept up in that and removed to Mexico before they have a chance to see a judge or a chance to prove their citizenship. So that is something we also assist with. And then we have a humanitarian program in Mexico as well, because as I mentioned, the conditions are very harsh. A lot of people are living in very substandard shelters. So we help with food, we help with clothing, just a range of things for people who are forced to wait for a long time, because if they don't survive, they can't make it through the legal process. So we really see that as an integral part of our work. I want to talk a little bit about some of the challenges with the legal orientation program, that pro se assistance program, particularly in the border region. So there's a lot of linguistically isolated people or people who speak rare languages. And so this is especially a problem for Indigenous language speakers. We've seen it time and time again where individuals don't get an interpreter they can actually understand, right? They can be, for example, from Guatemala, there can be several different versions of the same Indigenous language that are not mutually intelligible. We've had clients where we've gotten their cases terminated because they could not find an interpreter, but we've seen many more people who were deported because they just couldn't present their case. They couldn't conduct the interview because they didn't understand the interpreter. This issue with Indigenous language representation and access to services is also really difficult for the reunified families. So I mentioned we bring back parents who had been separated from their children, and we also are just about to launch another pro se assistance program that is federally funded. And it came out of the lawsuit that stopped family separation, you know, the Trump version of family separation. There's still a lot of other family separation going on. But essentially this lawsuit and the settlement created a path towards citizenship for reunified families in the US. And that path is going through the asylum office and an affirmative interview. So a lot of these families were already in immigration court. And so in order for them to access the asylum office, they have to do a motion to terminate their proceedings and then present at times very complex affirmative asylum application before the asylum office on their own. And so our legal orientation program is meant to help them through that process. And we haven't started yet. We're just kind of finalizing the contract with the government. But I was really disappointed to see how few resources were put into this. And, you know, it is very difficult to write those motions. You have to argue them before the judge. They're not automatically granted for these families. And then you have to prepare a voluminous asylum application with all of your evidence translated into English, and then go before the asylum office with your own interpreter to present your case. And so I anticipate that we will be providing a lot of unfunded services, especially for Indigenous language speakers who would not be able to navigate that system on their own. So I already mentioned the credible fear interview process in detention. So again, it's very expedited. In many cases, we can't talk to the person before their credible fear interview, but we meet them after it's been denied. And so they do have the opportunity to request an immigration judge review, where the immigration judge can hear what went wrong, you know, if they couldn't hear the interpreter, things like that. But you are not really entitled to effective representation in those hearings. So, or representation at all, really. So we have confirmed with the immigration court that we can send an attorney to those hearings, but they can't talk. So it's a lot of times just a rubber stamping of the denial. And it's very difficult. You know, the process that I think Lisa mentioned, where you get to know your client, you know, maybe at first there's telling you that the reason they fled doesn't fit into the definition for asylum, but after talking with them some more, you really work with them so that they can frame their story in a way that fits into one of those categories, one of the protected grounds. We don't have time for any of that before a credible fear interview. And because we cannot really represent someone in that immigration judge review, by and large, those cases are, you know, the denial is affirmed by the immigration judge and the person is sent back to their home country. And President Biden did institute his own version of the asylum ban, which basically makes someone ineligible for asylum if they didn't use CBP-1, which I mentioned is not very accessible. It's only in a few languages, and it's just difficult to access overall. If they didn't apply for asylum in another country before coming to the United States, or if they entered between ports of entry, which again, many people are forced to do because they cannot access the port of entry. And so what we're seeing now is people going through that credible fear process with all of, you know, the deck is stacked against them. You know, you have to make these very sophisticated legal arguments to overcome the asylum ban, which many people cannot do. So I think the last statistic I saw, it's about 60% of people are failing the CFI, at least in the San Diego region. And that is a much higher rate of denial than we had seen in the past. Something else that's contributing to the denial rate is the fact that they are conducting credible fear interviews now in Border Patrol custody. So Border Patrol custody is exponentially worse than the ICE detention facilities. The facilities are purposefully kept freezing cold. You're usually in a cell, concrete cell with 50 other people. You know, you're sleeping on a concrete bench. There's one toilet. It's in view of everyone. We've documented that people get rotten food or inadequate food. They have inadequate access to medical care. Most importantly, we call it the black hole because you cannot communicate with anyone outside when you are in Border Patrol custody, including your attorney for the most part. So this is a huge issue with representing migrants who are trying to access the asylum system. So we, for example, when we're working with individuals who are released to the streets of San Diego, have documented over 1,500 individuals who are separated from their family members in Border Patrol custody. So about 40% of those separations are spousal separations, so wife and husband. Sometimes there's a minor child involved, so mom and minor child will be released, and then dad is detained, sometimes sent to another state. And so during that time that they're in Border Patrol custody, when we document the separation, we send a G28 form, and that is the form you use to enter your appearance as an attorney, as a representative of that individual. And we were filing those forms to try to figure out where these family members were. And Border Patrol did not respond. I think they responded maybe to the first 50 forms and then just stopped responding. So we could not get any information about where the person was. I spoke to Border Patrol leadership, and they told us that their policy is to give that form, that G28 form with our information, to the person who's detained and then give them an opportunity to call. However, we have not received a single call from detention. And we know from just years of litigating conditions in Border Patrol custody that people are rarely afforded those phone calls. And so We've seen individuals detained in the black hole of Border Patrol custody for up to 30 days. It's taking us an average of 2 to 3 weeks to figure out where the person is. They're in Border Patrol custody maybe for 3 to 5 days, and then they're sent to an ICE detention facility. And then there is an online ICE detainee locator, but it usually takes 10 to 14 days to be updated. So during those weeks, the separated family members have no idea where the person is. And because we can't contact them, a lot of times we don't get to speak with them until after their credible fear interview, which again is coming very fast when they're in detention. So it's, even if you have all the lawyers in the world, which we do not, working at the border, just the act of actually representing someone in this environment is very challenging, especially because we're not getting any cooperation from the government. And then, when people do get into ICE detention, we have documented a lot of serious rights violations, both in our work with the federally funded legal orientation program, but also just, having met people in Mexico, and then they know to contact us when they go into detention. And especially when we are working with a federally funded program, we have to really balance our advocacy for that person who's experiencing rights violations with all of the confidentiality provisions in our contract, and the fact that we need to maintain our access to the facility. So if that is taken away from us, we can't help anyone. But we are documenting rights violations as serious as sexual assault. We have documented during COVID, for example, that detainees were being sprayed with toxic chemicals, and we had to be very careful about how we could actually advocate for those individuals. And in many cases, it involves pro bono representation from nonprofits or firms that are not receiving that federal funding and therefore are not, restricted in the same way that we are. The other thing that's just really difficult about this is that people who are in detention are in crisis mode, or people in Mexico are in crisis mode. So it's really, it's a lot of information when we're helping people pro se. And so it's really difficult for them to absorb all of that and move forward in a way that is productive. So I will just mention a few more things very quickly. So we are also engaged in...
Very quickly, Erica.
Yeah, very quickly, sorry. And this is something Lisa mentioned too. We have to litigate in federal court to address rights violations. That has to be part of our work. Again, it's very difficult to do that for people who are already outside the United States, but we try our best with pro bono firms. And then just the last thing I'll say is the law exists, but the government doesn't always follow the law. And so we have to engage in human rights monitoring to make sure that asylum seekers are afforded the very few rights that they are afforded under US law. So thank you.
Great. Well, thank you all. And maybe Andy and Lisa, if you could put your video up, then we'll move to the Q&A. And I already have quite a number of questions, and so I'm going to go through them and ask. In some cases, the questions cover a few different issues. But Lydia has a couple of questions. One is with regard to the immigration judges. She notes and knows some of the work you've done, certainly, Andy, on asylum roulette, refugee roulette, shows that there's a great differential in the grant rates of immigration judges. And she's asking if there's any oversight of the judges, and is it true that most judges are former ICE lawyers? So that's one part of the question. But she also is asking about the Franco asylees. I assume she means Holder versus Franco, or Franco versus Holder, and the fact that there is required representation for a category of people, what that is in more detail, and also is it perhaps a model of litigation that could be followed to expand the mandatory representation of other groups? So I'll start with those questions, judges and Franco.
Okay, so and my colleagues may want to jump in at any point. Feel free
Sure.
to. To start, is there real oversight of the judges? No, I mean, it's an interesting issue because, the judges would like to think of themselves as independent. Sometimes they are, sometimes the political nature of an administration will make that more difficult, but they don't like to think that they're supervised. They don't like to, be told what to do. Sometimes there's some pressures on them to move somewhat more quickly with cases than others. But no, and even more importantly, or as important, maybe it's more important. There's no great training of our immigration judges. You have to have practiced for 7 years to become an immigration judge. And it's true that at different periods of time, more INS or now ICE attorneys who are prosecuting cases have become immigration judges, but there actually are a range of judges. It does depend on the administration who's being appointed, because the Attorney General, at the end of the day, it's really the Deputy Attorney General who gets recommendations from the director of the Immigration Courts and Board of Immigration Appeals. It's called the Executive Office for Immigration Review. It's a political office that's making these appointments. And the judges are not administrative law judges or federal court judges. They're not independent and, in that sense. And so it's a challenge to make that work. I do think that there's some excellent judges there. I've seen some wonderful appointees. Susan was actually involved in the 1990s in trying to make more representative of the immigration world, the Board of Immigration Appeals members, the administrative appellate group that made decisions. And that worked for those years, but then another administration came in and did away with the many of the judges that came from advocacy or practice or academia. So there's been a constant battle between, and it seems somewhat between the Democratic and Republican administrations, but it's not only that. So it's still easier for an ICE attorney to become an immigration judge, and that's just part of the way the hiring goes in the government. But the bottom line is there should be more diversity, if you will. And when I say diversity, not just in the professional background, but actually in who is. I mean, the judges should look like the rest of the country does. So that's a challenge. Very briefly on the Franco decision. So it's an excellent decision that helps those who are determined to be mentally incompetent to have some form of representation. But I just want to note the limits of it too. It's based on a statute that is not going to help most asylum seekers or other immigrants who are trying to seek relief, because it's a health statute, a mental health statute. So it's limited in it's what it can do, and it didn't mandate representation with counsel. It didn't say to the immigration courts, you have to hire judges now, you have to pay them. What it said is you have to find qualified representatives who are, among them, the accredited representatives that many charitable organizations have, and who are very good, but they're limited in numbers, so that they can only go that far. It also included, it was pretty funny to me when I read this, law students and recent law graduates. Well, you're just not going to get that far with that. So it was very good. It's an important opinion and decision. I wish I think the way that, we see things moving forward is at some point in time, there will be an understanding that, mandated representative for indigent asylum seekers and immigrants would be worthwhile, because it will help the court be more efficient, more effective, and fair. But we're a long political ways off. So in the meantime, you have to depend on the various states and cities that are trying to build this. And we see some examples here tonight of that.
Lisa, do you want to add anything on that?
I just want to add that our organization is one of the qualified representatives that receives federal funding. I love it. I love that program. What's great about it is that we get funded for representation for the duration of the case and can go all the way to the Supreme Court, which is not normal for a lot of the local and state funding. And so, we get a lot of state funding, for example, from California, which is just for 1 year, and no asylum case lasts 1 year. So it's very limiting in terms of how far we can go with the case. So I think the Franco case and the National Qualified Representative Program should be a model, but like Andy mentioned, we're very far away from seeing that as a political reality.
Yeah, there have been efforts to emulate the success of Franco for other populations, in particular unaccompanied minors, that just haven't really gotten out of the gates. They just haven't found traction, despite the abundant evidence of the significant disadvantages that a toddler has appearing pro se before an immigration court that just hasn't gained traction in the way those Franco did. NAJC is also an NQRP, a National Qualified Representation Program. Totally concur that those are the sorts of programs that need to be expanded. And while the success might not come through litigation, the hope remains that there will someday be the political will to do the right thing and create a system where asylum seekers can meaningfully access counsel.
I have two different questions, two different people, but they're basically getting at how do people find counsel and what's the process, and are there mechanisms that could be used to ensure that everyone who needs representation knows what legal options they have in front of them can be done to improve that. And then a very specific question is whether there are university clinics in Texas and universities in Texas that have clinics. But let's take the broader issue first. And how do we improve the resources available to people in search of representation? Maybe Lisa or Erica, you could start.
Yeah, Lisa, if you want to start.
Go for it.
I usually give our clients at the border the link to the Immigration Advocates Network legal directory. So that is a directory of basically all the nonprofits that are doing both defensive and affirmative representation. And you can search by zip code, or you can search by detention facility. But you really have to already know or be connected to a nonprofit to get that kind of resource. And there's other kind of directories like that out there. What's kind of problematic is the pro bono list you get with your notice to appear from the immigration court. And probably Andy and Lisa can speak a little bit more to this, but my understanding is it's not really vetted. It's not necessarily accurate. So just for example, when we had Remain in Mexico, there were organizations listed there that didn't take those types of cases. And because there's only a few organizations or attorneys listed, usually they don't have capacity because there's so many people calling. So I think it's, there are systems out there that are very good and some organizations that are doing great work to try to get that information out. But I would say it's far from adequate for most people.
Yeah, I think it's just how to connect asylum seekers with counsel is absolutely the $1 million question. It is, we've hired consultants, we've surveyed other organizations, we've tried different models to figure out what is an equitable way to make ourselves available to asylum seekers. And because the need outpaces capacity to such a degree, so many people call and never got through to us. And we feel absolutely terrible about it. And we've tried, I mentioned our immigration court help desk that's physically present at the immigration court. We also, during the pandemic, got approval to start an immigration court hotline. So we have a phone number that people can call, and through that, they can get referred for a full asylum intake. They get that pro se support, but then also in some cases can get a full asylum intake with us. But we just, again, that number got so, I mean, our backlog is just in the thousands at this point of people that are seeking services. And I know our teams just anguish over not being able to be responsive. We try to not do a full asylum intake unless we have capacity to take the case. We don't think we should put people through the trauma of a 2 or 3 hour interview about their asylum case. If at the end of the interview, we're going to say, yeah, that sounds like an asylum case, but we don't have an attorney to help you. And so we do a limited number of asylum intakes to make sure that we can say yes if the case is there. But that means we're saying no to a lot of people. And I think, the answer is building capacity, building pro bono attorneys, building law school clinics, building nonprofits with the resources to do the work, and also fixing the system so that we can be done with a case in 6 months instead of 6 years, so that there's space for new cases to come in. It's a very depressing answer. I'm so sorry.
I'll just add and build on that just a little bit. We have an extraordinary civil society in this country and in the immigration field too. So we have absolutely wonderful advocacy organizations. The need is just so great that there's no way, as Lisa was saying, and Eric was saying, there's no way that they can fulfill all this need. So there, at some point, we need something more, some type of universal representation system. And it has to start at the beginning. It's so much better overall if it starts at the beginning, because then an asylum seeker or an immigrant would have a better idea. Do they have a form of relief available to them? Should they be, what can they do? And what can't they do? What is not going to work for them in the long run, right? Lawyers can really play that role, but we have to reimagine how that's going to happen. I almost feel like we need both the resources, but an organization that will actually organize it all and then help people where they're going to make sure they connect with an organization. Because the way it's left now, it's word of mouth. It's serendipitous. If you happen to be connected to a good advocacy organization, and they have the resources at that moment, yeah, you're in good hands. But otherwise, it's a great challenge. And so it's very hard to put all of this on civil society without giving them the resources that they need. And I'll answer the Texas clinic question quickly because I did some research as we were going. So UT Austin has a great clinic led by Denise Gilman that's similar to Georgetown. Denise was a Georgetown fellow, and she's been a prof ever since. She's great. University of Houston Law Center, Texas A&M, Baylor, and Texas Southern University, the Thurgood Marshall School of Law are the ones that immediately popped up, and there are probably some others.
St. Mary's, you got to throw St. Mary's into the mix. Incredible work.
While we're on the subject of resources, so another question about asking whether you'd comment on the role of non-attorney representation for migrants, and are those working? Does certification make a difference? Is that a way to expand the pool of representatives? So,
yeah, if we're talking about DOJ, Department of Justice accredited representatives, then absolutely, those are really invaluable resources. At NIJC, we have, many of our supervisors and senior staff members are accredited representatives. So these are people that didn't go to law school, but built immigration expertise over the course of their work at a nonprofit. And then you can apply for this certification that allows you, there are 2 different levels that allows you to appear in different capacities before you at the United States Citizenship and Immigration Services, or in some instances, the Immigration Court. That's a real undertaking to become an accredited representative, and it works best when an accredited representative, I believe, is housed in a community of advocates. A lot of times, accredited representatives, might be connected to a church and be involved with a really small practice. I think it might work well there if you have a more narrow practice, but I think that's asking a lot of an accredited representative to not have sort of that network of support that you find at a larger organization. I think outside of that, what can non-attorneys do to support asylum seekers? I think language support is huge. If you're someone that speaks another language and can do interpretation, we have here in Northern Indiana where I am, we have a network of volunteers that help drive our clients, and that there's sort of like an informal Uber network, because in Northern Indiana, if you're driving and you're not white and you are, appear to be potentially an immigrant, then the likelihood is high that you'll get pulled over and potentially arrested for driving without a license and transferred to ICE custody and placed in deportation proceedings. So services like that are really, really significant and useful. So those things can be really helpful. I don't know if others have other ideas.
We have quite a few accredited representatives at El Otro Lado, and have always, in all the organizations I've worked at, we've trained accredited representatives. Aside from expanding the pool of people who can represent individuals, it also helps members of directly impacted communities get into a representation role. So we have a few attorneys on staff, or accredited representatives, who are attorneys in another country and now are able to represent immigrants. We have accredited representatives who just grew up very poor and maybe grew up undocumented, didn't have the resources to go to law school, who now can step into that role. And so I can tell you it's very difficult to hire attorneys who are immigrants, who are from disadvantaged communities, because the percentage of attorneys from immigrant communities and from disadvantaged communities is very low, because law school is expensive. And also for those who get in, a lot of times they can't work at a nonprofit. We don't get paid that much. Maybe they have to take care of their families and take that big law job, which I don't blame them for. So I think not only does it increase representation, it really increases the diversity of people who are representing migrants.
I just wanted, Mr. Schatz in the comments talked about the importance of volunteer mental health and medical personnel being involved in cases. That's huge. We rely very heavily on therapists, psychologists, psychiatrists who support our clients in really critical ways, and also provide forensic evaluations that we use in court that judges often give significant weight. So just wanted to highlight that as another way that non-attorneys can play really significant roles in asylum cases.
Right, the League of Women Voters is a nonpartisan organization, so we don't support any particular candidates, but we do have positions that have been taken after studies that have been done that provide clear evidence. So one of our members has asked mostly about the politics of this, and what will be done if there is a change in administration come the next election. And are you preparing for that? I know how bad it was not really recognized immediately in preparing for the last time we had a president who was very negative about immigration. And I won't go beyond that, but are your groups preparing for it? And what do you think can be done to ensure that there continues to be some level of due process?
I think it's already pretty bad at the border, because both Democrats and Republicans have gone pretty far right when it comes to protecting access to asylum. It's hard to think about it getting worse again, honestly, because it was, being on the border during the Trump administration was, traumatizing to say the least. And it's continued to be traumatizing under Biden. We see a lot of suffering. I think that we're there. Mentally preparing, sure, trying, but what makes it difficult is we can't really litigate to protect legal rights when there's a violation of the Immigration and Nationality Act because of a 2022 case called Aleman Gonzalez. We can't get class-wide injunctive relief by and large when the government violates immigration laws. So we didn't have that during the Trump administration. We were able to stop a lot of the worst policies that were proposed. We don't have that luxury for, if there is a next Trump administration. And we're already seeing the effects of that with some of the litigation we're engaged in at the border. The government's violating the law, they know it, and there's nothing the courts can do to stop them. So maybe that's not the most uplifting answer, but yeah, it's hard to think as an attorney how we would confront any Trump administration.
Yeah, I think we're deeply disappointed in the Biden administration for a lot of reasons, but I think it's not accurate to say that they are the same, and that shifting back to a Trump administration wouldn't be worse than what we have now. So I do see it as a very real threat and a very significant risk. I mean, I am absolutely filing motions to expedite in a bunch of my asylum cases because I'm very concerned that gender-based asylum claims will be once again more directly under attack as they were under the Trump administration. And this goes to, Andy was talking about how political the Department of Justice and the Board of Immigration Appeals is, and they can change the way legal precedents apply. And so I am very concerned that it will be even harder for people to win asylum, particularly a lot of my practice involves survivors of domestic violence and other gender violence. And so we are filing motions in court to get cases heard as quickly as possible. I've talked a lot about those immigration court backlogs, so it's certainly an uphill battle, but that's one of the things we're doing. We're also, working hard to keep our litigation team strong. I think there will be a need for federal litigation. I think it's going to be hard. I think if there's another Trump administration, they're going to be smarter this time. They made some really clumsy mistakes last time and made it possible to get some of the worst programs enjoined and eventually stopped. I think it will be harder if it happens again. So I think, it's a very significant threat that we should be preparing for.
Yeah, please while you're we have a question that deals with one of the issues that you were just discussing, and that's to explain why there isn't a protected group of women being female, and what is the argument that makes it a difficult issue?
Yeah, there have been years and years of litigation and policy work trying to resolve this or clarify this. In the refugee definition, it talks about being persecuted because of a characteristic like your race, religion, your nationality, your political opinion, or your membership in a particular social group. And where gender claims have generally fallen is in that last particular social group, or PSG prong. And there have been, the litigation on this is really fascinating. In the Ninth Circuit, there's what's now a pretty old case called Perdomo, where the Ninth Circuit came awfully close to recognizing gender as a particular social group. And that case kind of washed out on remand before the Board of Immigration Appeals was able to kind of do what the Ninth Circuit was suggesting that they do. And then more recently, the First Circuit in a case called Peña Paniagua also said, this question isn't quite before us, but we think gender might be a particular social group, that gender alone might work. What happens more often, at least in the cases we litigate, we regularly make the gender argument. It's pretty standard in pretty much every brief that we're filing where there's a gender-based claim. We usually win our cases on a more narrow particular social group. So in 2014, the Board of Immigration Appeals issued a precedent case called ARCG, which is just a part of the alphabet soup that is the Board of Immigration Appeals decisions. But ARCG was a decision that recognized married Guatemalan women in relationships they can't leave. So it was this kind of like fraught particular social group that was kind of cobbled together and meant to be more narrow than gender alone, because there's always been this concern that by granting gender as a particular social group would open the floodgates and every woman from Guatemala or Honduras or whatever country, which Andy's shaking his head because of course that's not the way asylum law works. But there's been this fear that that's too broad of a ground. And so we do often win our gender-based claims. We just win them on the more narrow women in relationships they're unable to leave ground. And so that's under the Trump administration. That's what I was referring to. So they issued, when Attorney General Sessions took power, he issued a precedent decision called Matter of AB that said, we're pretty sure that domestic violence-based asylum claims really should never win. And so for the duration of the Trump administration, that was the case law. And then when the Biden administration, post-inauguration, pretty early on, Attorney General Garland issued a subsequent, so there had been a first and a second Matter of AB, and Attorney General Garland issued a third Matter of AB that said, okay, this is no longer precedent. We're going back to that ARCG group of married Guatemalan women in relationships that are unable to leave, and that's a group that's now cognizable. So that's now recognized under the law. So that's the state of the law right now, but it could just as easily swing again if the administration changes. And I think there will continue to be litigation seeking to recognize gender alone as a particular social group. Again, we've argued it in, I don't know, 5 or 6 different circuits. Usually we end up winning on another ground, and it's in our client's best interest to take the win rather than continue fighting for recognition of gender as a PSG.
Thank you. I remember those fights from way like 40 years ago when I was writing the guidelines on that. Andy, I'm just going to let you have a final word, and then I see Jane has popped up because she'll be closing the meeting. So,
Great.
Andy?
Great. I just wanted to say on the gender issue, because it's such a wonderful and common sense question. One would think, why is that not so clear, right? Well, the system's become very what I call legalistic. And partly because it's now ruled by judges and attorneys for the government and attorneys for the advocates, right? And they're all and there's a sense, as Lisa was describing, of trying to figure out how do we limit this from some governmental point of view. It's how do we limit this? And this fear that, well, if it was gender, all these women would come. Well, look at the other grounds. Religion. If somebody is persecuted because they're, of any particular religion, think about how many millions and many more of that group is around. They're not all coming to seek asylum. The same thing is true with gender. The high courts of other countries have recognized for years that very easily put a nationality with gender. Pakistani women, for example. It's not all Pakistani women, but Pakistani women who've been targeted because of their gender and their behavior. Okay, it's not that difficult to get at, but it's been terribly fraught with politics ever since Janet Reno was in office, and they might have solved it back then, but they didn't. So we're stuck with it.
Thank you. And let me give my thanks to all 3 of you for fantastic presentations and even better responses to a lot of different issues that came up. But let me turn this back to Jane.
I also want to add thanks just for your work. I mean, your stamina, your commitment, your humanity. It's so wonderful, and we just can't appreciate all of you enough. I just want to end by saying, our group is going to continue to meet. We are hopeful to have a workshop at the convention in DC in June. We hope that any of you who are coming to the convention will come to that workshop, because it does become kind of a networking opportunity for those of us who care about this topic. We will have the video available, so you can let your friends know, and we look forward to more opportunity to have important discussions about this.
Jane, where is the video, please?
Catherine will figure that out. We'll send it out.
We will send it out, and we will continue to provide not only the video, but some of the questions that could not be answered in the chat. They were all really good questions, but time is of the essence, and we've used these wonderful people's time already. But we can only stay in touch with you if you contact us. You have Jane Andrews and my email addresses. Please send us your contact info so we can add you to our distribution. Jane has just put hers in the chat again. If we hear from you, you will hear from us. And we certainly hope if you are League members and plan to be at the National League Convention in June in Washington, D.C., you will hear much more from us. We will be as visible and as present as we possibly can. Thanks, all of you.
Thanks so much.